Case number 23-00552, Christopher Powers.
Kyle Paskulovich, appearing on behalf of the people.
Good morning, Your Honor. May it please the court, Lowell Friedman on behalf of the defendant, Christopher Powers.
All right, Mr. Powers, state your name.
Christopher Allen Powers.
Okay. Today's date and time set for probable cause conference. What are we doing today, gentlemen?
So, Judge, just retained. I received discovery. I've already had an opportunity to speak with, I don't want to rename it. How do I pronounce your name, Kyle? Mr.
Paskulovich.
Thank you. I received some videos late last night that I need to review. So for purposes of today, Your Honor, what I'd like to do, and I've discussed this with my client already, is waive the 21 days on the probable cause examination. So as you can tell, my client's in custody right now. It's a $30,000, 10%. His mom, who's part of this Zoom, plans to post the $3,000 so he can be released back to his particular apartment building and his unit. At which point, when he's free, he'll be able to come to my office. We'll explore the discovery and the video. In the interim, I will be drafting up a deviation letter to see if we can address the felony in this case. So, Your Honor, if we could push it back about 3-4 weeks, that would be fantastic.
Okay. So 3 to 4 weeks, Mr. Friedman?
That would be ideal, Judge.
Okay.
Yes, do you not hear me?
Yeah, you're breaking up a little bit. So
I'm sorry, I'm stuck inside the Plymouth District Court.
I have to reach out to them about their Wi-Fi service. So, all right, Mr. Powers, you have the absolute right to have an exam within 21 days of your arraignment. Obviously, in order to get all of the information that he needs to get and have the opportunity to speak with you about all the potential issues related to this case, there's a need to move this case outside of those 21 days. You don't lose the right to an examination. It just doesn't happen in the first 21 days. Are you okay with that? Is that a yes?
Yes, sir.
Okay.
Yes, sir.
All right, prosecutor, you are willing to waive the 21-day rule as well?
Yes, Your Honor.
Judge, can we reset this for another probable cause conference as opposed to setting it straight for an exam?
Will do. I'll set it.
Thank you.
Now, he is aware of his bond conditions as they are right now. There's, he is not allowed to return to that address, Mr. Friedman, that I can read.
Right, Your Honor. So you read my mind. What he lives in an apartment building, and the misdemeanor related to one of the tenants in a separate unit within the building. So it's my understanding, I haven't seen the bond, but it's my understanding that he certainly can't have contact with either of the two units at issue in this case. He's certainly prepared to not have any contact, just go back to his place. He doesn't leave his apartment much, and he'll obviously comply with everything that's ordered of him.
And that's, so the bond indicates that he is not to have any contact with the two, Miss Waterloo or Miss Brown. And he's not to return to 2816 Coolidge, apartment 11 or 12. I don't know how this apartment building is set up. I can't imagine what it would be like while a case is pending to see Mr. Powers just walking down the hallway or in common areas. If I were the individuals in this particular circumstance having managed the situation which caused Mr. Powers to currently be incarcerated. That's, I don't know the way that this apartment complex is set up. Maybe it's an entirely different wing of the apartment building, but maybe there's a common entryway, or maybe they all check the mail at the same spot. It is ripe for potential violations of the no contact order. Any thoughts from either prosecutor or defense counsel on this, how we manage this?
I would just state that I've talked to the victim, and she is definitely very traumatized by the situation. I think that she would be opposed to any incident where she'd see him.
So, Mr. Friedman, is there anywhere else he can stay? If I allow him to go back to get his property and take that somewhere else, can he go anywhere else?
So, Your Honor, I think that presents a challenge. His mom lives up north. He is divorced. He has a close relationship with his ex-wife, who he sees multiple times, but I don't know whether she can take him in. This was the issue last night. The only thought I have, and obviously I understand that we have to protect Miss Waterloo and Miss Brown. It's my understanding he doesn't leave his place very often. He doesn't work. He's quiet. He lives a very simple life. I don't see much of a need for him to have to leave his place. Perhaps we could set up a condition that if he is going to leave his unit, perhaps it's only in the company of, I'm just speaking out loud maybe here, spitballing, maybe his ex-wife, if she comes to visit, then there'd be a third party with him. But absent the third party, he would commit to not leave. I don't know if that's feasible.
Yes, it is, Your Honor.
So he'll stay in his place. He won't leave unless he's in the company of a third party. I have a letter from his ex-wife. She indicates in this letter that she's drafted to Your Honor's attention. I just don't know if you've seen it. I can say that as I'm reading here, she says here her experience of knowing and living with him in all these years. She doesn't believe he'd be a risk to anyone. He's been trustworthy, caring, and devout person. Family and friends willing to support him. If leniency can be considered, she's optimistic. That would be great motivation. So I think from what Christopher is nodding and affirming, that he would agree not to leave his place unless he's in her company, which isn't going to be frequent.
So I'm going to go off YouTube